He'll just play out the stuff and then we'll start. Thank you everyone for joining us from across the world on our live stream, and thank you to our live audience here. My name is Amish Tripathi. I'm the director of the Nehru Center, and of course the guest sitting next to me needs no introduction, but I will still do the formalities. Justice Dhananjaya the Honorable Supreme Court Justice, and will be the Chief Justice soon. In a few months, an accomplished lawyer, one of the finest justices we have in the Supreme Court, and it's such a delight to be hosting you, sir, at the Nehru Center. This will be in the form of a conversation, so I will be asking Dhananjaya ji a few questions, but feel free, sir, to break out into any remarks that you would like to make, and we will have some time left over for a question and answer session with those of you in the audience as well. There is, of course, a formal introduction to Justice Chandrachud, that he is a Supreme Court Chief Justice, but I should tell you a bit more. I've known him for many years, and I passed through a difficult personal phase for a few years. And especially at 3 moments when things were very difficult, he sent me long messages, he called me and spoke to me for a long period, and that shows for such a busy man the levels of compassion that he has, which is rare to find in someone so senior. So the first question to you, sir, is actually linked to this. How important is compassion for a justice?
Thank you very much, Amish. And before I answer that question, I must express my very, very deep sense of gratitude for inviting me over here, and to all of you for being here despite the strike and the dislocation which has been caused in London. And one preliminary thing before we go on to the question, which is if I'm left with a little time, I would like to ask Amish a question in my turn. But unlike the questions which he's asking me, which I have to answer on the spot, I'll tell him about my question right at the outset, which is I want to ask him at some point of time he can answer. Who is the inspiration for these brilliant books which he writes? So.
Lord Ranger, thank you so much, sir, for coming. Please do.
Now coming back to Amish's question on the value of compassion, when it comes to justice, using particularly the ancient traditions of India. The origin of human rights and the judicial system can also be traced to the Arthashastra, written in the 4th and the early 3rd century BCE, which spoke of promoting justice, the creation of a just penal system, the equal protection of laws, irrespective of caste or political belief, and the like. So we have Article 14 of the Constitution, which gives us a vision exactly of this precept and these doctrines which are borne out in the Arthashastra. Values such as the respect for the rule of law, the protection of the innocents, kindness and compassion to others, the development of a community, these have been entrenched in India's ancient manuscripts, and these values have really informed the drafting of our constitution. Now, I must tell you this, that as a judge of the Supreme Court, I hear almost 200 cases every week, and the most challenging aspect of adjudication is to learn how to balance competing values, maybe human rights on the one hand, or the environment on the one hand, against the need for business and development, the grant of bail to an under trial, as opposed to ensuring a fair investigation and protecting the rights of the victims, the freedom of speech or of expression to enjoy life, and respecting our duties towards others who may be offended by the exercise of freedom of speech. Though these issues may seem to be very abstract in nature, behind every case, Amish, which comes to the court is the compelling story of a human being, and the black letter of the law comes to life in the context of the human stories of injustice, of suffering, and of pain, which we hear as judges. And though people may like to imagine that we are disconnected from the individual stories and we sort of sit there and only decide the law, that's not quite true. Judges are trained in the law. We are not necessarily trained to be compassionate, but compassion is a matter of your instinct, and which is guided by your own experience, by your own personal values, what you learn as little children, what life teaches you. Many of us have our own stories of distress, of pain in our personal lives, and I think we come out of that perhaps looking better and with a certain degree of aspiration. For instance, I'll just give you a couple of ideas in compassion, couple of instances. We have cases, where married couples get into distress, and there's a long drawn-out battle over the custody of the child. It's sometimes complicated when the parents are based across national frontiers, maybe one spouse in Silicon Valley, the other spouse in Bangalore or Gurgaon, and they are sort of battling over the custody of a young child. Similarly, in bail hearings, in hearings where somebody is accused of a crime, you need to look at not merely the interests of the accused, because there's a presumption of innocence in our law, that every accused is presumed to be innocent until they are proved to be guilty. At the same time, you have to balance the interests of the community. If the crime involved is a heinous act of rape or of murder, then you must also look at what the feelings of the community would be. So, really speaking, compassion, which we now speak of in terms of compassion under the Constitution, which we'll perhaps talk about later on during the course of our conversation, this compassion which we inherit is also an inheritance of the past on who we are as Indians and who we are as a community, and how have we imbibed the values of who we are from the distant past, the not so distant past, and from the present itself. So these are all the constituent elements which go into defining our sense of compassion as a nation today. And I do believe that you take out compassion from judging, and you would be left only with the husk, so to speak, of judging. The essence of judging is compassion, which is really the truth and the essence and the substance of who we are as a community of judges.
I couldn't agree more with you, sir. And before we carry on behalf of the host of the evening, Deputy High Commissioner Sujit Ghoshji, I'd like to also welcome Lord Ranger, Lord Bilimoria. Thank you so much, sirs, for joining us. And I'm doing this on behalf of the host. I'm sure you guys. So if I may move to the next question on this. There is a question that arises a few times, and it's more in the higher courts. That do you think that the fact that the language used in our higher courts and the Supreme Courts is still English, which a vast majority of Indians are uncomfortable with, even those who know English, it may not be their first language. Many of the procedures would be a little foreign to them. So is there a case to be made that much of our higher education is still colonial and therefore a little difficult for the vast masses to access without the benefit of a good lawyer?
The primary the primary audience of the judicial process is of course the litigant who is before you, because you are rendering justice to that litigant, and or both the litigants if they are private parties, or if there's one litigant who is a private party and the state. So you're trying to balance the needs of justice. So you speak to the parties before you in the primary sense, but your secondary audience, which is perhaps even more important, because that's when you speak to the entirety of the community. Not just to the parties who are before you, particularly in the Supreme Court. When we lay down law, we are of course laying down law in the context of the dispute between private parties, but we are also speaking to the community of what we envision as a just society in our country. Now, with that sort of an object which we as judges seek to achieve, it's important that the language of our discourse must be understood by the people for whom that language is meant. And we should not be speaking an alien language. Now, Article 348 of our Constitution provides that the proceedings of the Supreme Court and of all the high courts should be conducted in English. And let's also trace the reason why the constitutional framers, I mean, they were very distinguished drafters. Dr. B.R. Ambedkar led the drafting of the Constitution. And the reason for this provision was that India had adopted the common law as its legal system. And a number of legal principles were drawn from the courts in England at that time. But there was a more fundamental reason, which is that the Supreme Court and the High Courts are courts of record. The precedents of the Supreme Court can be cited across the country. The precedents of a High Court can be cited across the country. Various decisions of the High Court are in challenge before the Supreme Court. Now, in order to ensure the uniformity in the interpretation of the law and to represent a unified judicial system, English was adopted as a language of court proceedings by the Constitution for the Supreme Court and the High Court. Now, that's constitutional doctrine. The reality is a little different. And I can share with you, because I was a judge of the Bombay High Court for 13 years, and then I moved as Chief Justice of the Allahabad High Court, where I was Chief Justice for close to 3 years, actually 2 years and 7 or 8 months. And the reality is a little different. For instance, when I moved as Chief Justice of the Allahabad High Court, the proceedings would of course commence in English, and the lawyers are used to saying, "May it please you, my lords," when they open their arguments. Now, this my lord has become more of a takiya kalam more than anything else. So when the lawyer forgets what to say next, they tend to say my lord only to fill in the gap. Not because we are lords. I would be happy if people called us sir. But the point is, the moment you asked a question, the lawyers would address you in a language with which they are comfortable, which was Hindi. And I had no problem about the fact that the lawyers would speak to me in Hindi. I would begin with a caveat by saying, please forgive me for my response in Hindi, which is Bombaya Hindi Mishrit, thodi si meri bhasha hai. My language may not be completely pure, but they took to you because they realized that you are making an effort to make yourself understood in a language which was close to everybody's heart. And of course, it's our national language, so I take great pride in the fact that I could address everyone in English in and outside the court. It's a language where I learned as a student of my graduate education. I have read extensively Hindi literature, and therefore I believe that, it's important to make yourself understood in the language of the people. Now, the point which you make is really well taken, because it's important that the judgments of the Supreme Court and of the High Court, which are delivered in English, must be made known to citizens across the country and in a language which is known to them. And incidentally, the Honorable President of India raised this point at a lecture which the Honorable President delivered while addressing the Constitution Day celebrations in the Supreme Court, that why can we not therefore make these judgments of the Supreme Court particularly available to all Indian citizens? And technology provides us a solution. In the olden days, we had to sit down and get a translator, appoint a whole team of translators. Technology today does that, at the flick of a button. So the E-Committee of the Supreme Court, I chair the E-Committee of the Supreme Court, we have a segment on the use of artificial intelligence. And one of the missions of the E-Committee, and guided by the Chief Justice of India, is that we must be able to translate our judgments into all Indian languages so that, citizens can access them. The services which the E-Committee provides, including, we will speak about that a little later, all the services which we provide, including our manuals for how should you e-file documents. Now, we are providing for e-filing of documents in court to facilitate judicial proceedings and curb laws delays, or various other services. We send SMSs to litigants on when their case is now going to be listed. We send emails free of charge to litigants. I have in fact the figures which I'll talk about if we have a little time. So all these services which we provide must be provided in a bilingual form, in English as well as in the local language which is available to the litigant. So we are increasingly using, we are using the languages which are in vogue across India for disseminating our services. So though at a certain doctrinal level, yes, the language is English, the actual reality is very different. So we are very, very relaxed in the use of any other language, particularly in the courts in which we preside. Even in the Supreme Court, I may not be able to speak Kannada if I get a Kannada litigant arguing before me, but certainly if I have a litigant who can converse with any of the languages which the judges on the bench use, we are happy to converse with them and make ourselves known in a language which they can understand. But the Supreme Court makes it a little more difficult because it's a national court, and therefore, we have to have a unified language which we can use for the record.
Fair. In a country of our scale, with the number of languages that we have. And the line below the Supreme Court logo is Yato Dharmas Tato Jaya, which is from the Mahabharata, that where there is dharma, there is victory. But often what ends up happening is one may not be able to benefit or get victory from it if many cases take too long. And there has to be a victory of justice, but it has to happen smoothly and fast enough that there is a sense of justice coming in at the right time. This is an issue that, yes, the Supreme Court has reduced much of its pendencies, but among the lower courts it's still quite high. How does one address this, sir?
Well, I might almost sound to be cliched when I say that, we all learnt about this doctrine called justice delayed is justice denied. And then the flip side is, but justice hurried is justice buried. So how do you find the balance between the two? Now, one of the major issues which is faced by the Indian judiciary is the pendency of cases. There are today 70,852 cases pending before the Supreme Court, out of which 52,000 are pending admission, that is the initial hearing. There are about 5.97 million cases pending before the high courts and 42.1 million cases at the level of the district courts. So this is there's a huge backlog of cases which we can confront. What are the reasons for the delay? The delay is, of course, first numerous reasons, and I'll just only highlight a few of them. I might have missed some. Is the low judge to population ratio in our country, which is amongst the lowest in the developed nations. The lack of judicial infrastructure, sometimes frivolous litigation, multiplicity of cases arising before different fora on the same point. A case may involve a real estate dispute. The same litigant would try and use access to the consumer fora, to the National Company Law Tribunal under the Insolvency and Bankruptcy Code, so on and so forth. But there is another issue as well. As after 1990, as the economy has opened up and India has moved from a tightly regulated socialist economy into a market-driven economy, we've had a spate of regulatory statutes which have been enacted by Parliament in national interest, and you need those statutes, whether it be for the regulation of securities, or competition, or for the environment, or electricity, income tax, company law. So you have a tribunal governing every specialized act which the Parliament has enacted. Now, very often what has happened is that these tribunals have been set up without an effective legislative audit of the consequences of setting up the tribunal. And I think it is important that at least from here on, the lawmakers and of course the government as the mover of the law must conduct a legislative audit of what is going to be the impact of the law. I'll just give you a very simple example. Section 138 of the Negotiable Instruments Act was enacted, as a result of which the dishonor of checks, which was earlier a civil dispute, because if A lends 100,000 rupees to B and A gives a check which is dishonored, B can file a suit for recovery of 100,000 rupees with interest from A. Now, Section 138 converted it into a criminal wrong. So a person who is convicted can be sentenced to imprisonment, plus there can be an award of compensation, which is usually represented by the quantum of the check which was dishonored. Now, what has happened is that something which Parliament did to ensure that people pay their debts on time have resulted in literally lakhs and lakhs of cases coming to our magistrates' courts, and we don't have the number of magistrates to deal with these cases. So when new laws are enacted, which are undoubtedly necessary, there's no denying the fact that these laws are necessary, we have to also ensure that we strengthen the judicial infrastructure into ensuring that the backlog of cases is curbed. There has been a radical shift in thinking in the last few years. After independence, very little importance was placed on developing judicial infrastructure. Of course, there was a great deal of importance on developing heavy industry, on investment in education, in infrastructure, and so on and so forth. But on setting up hospitals and primary schools, important in itself. But people didn't realize, and I think the policymakers didn't realize the importance that the role of the courts in the overall economy. Unless you have a strong rule of law, you will not attract investment. And particularly now that there has been an emphasis on the ease of doing business, it's important that there is an adequate investment in terms of resources for our courts. Because when we have courts which are well resourced, they're able to deal with problems on time, in turn you will be able to attract investors. Otherwise, there's always a great danger that people who are not able to resolve their disputes on time will take to extrajudicial methods to resolve their disputes, which is a very dangerous thing. And this is not only in the context of, say, commercial disputes. Take the case of matrimonial dispute. If a matrimonial dispute is not going to be resolved, say, until a decade is over, or more than a decade, and take a case of a young couple which has a problem at the age of, say, 25 or 27. And if you're not going to resolve their dispute until they turn 40, valuable years of life are lost, and that affects the social fabric as well. So a great deal of importance has to be given. I think a thought has to be given by the policy planners. Now, the last part of my response to your question is, what can we as judges do about it? Because so much of it lies beyond our control, right? because the courts have to be funded by the executive, and funding is with the government of the day. What can judges do? And this is something which is not known across India particularly, not even known to lawyers. In fact, recently we had a very interesting interaction with the Parliamentary Standing Committee on the Department of Justice, and we interacted with members of Parliament across political lines, and we were delighted that they came to the Supreme Court. They spent a great deal of time understanding the work which we are doing in terms of technology in the Supreme Court. And I want to spend just a minute on that because I chair the E-Committee of the Supreme Court, and I have constantly been really emphasizing that technology can be leveraged to increase the efficiency and effectiveness of the courts. And we are, in the E-Committee, we are focusing on using technology to transform judicial infrastructure as a very important link in making our judiciary modern. Just to give you a few examples, during the pandemic, the first example is video conferencing. When the lockdown started in March 2020, if we didn't have a robust technological infrastructure, our courts would have to shut down. And people wouldn't have been able to access courts, get bail, get their disputes resolved in courts, whether on the civil or the criminal side. Now, during the pandemics, the court shifted to hearing cases virtually. This allowed us to ensure that at least initially, matters involving personal liberty could be taken up by courts. And as of April 2022, the courts in India have heard nearly 19 million cases through video conferencing facilities. Wow. And across the world, this is unheralded. I don't think any other country in the world has been able to use technology to the extent that we have used. But this is all not necessarily reported because this may or may not be exactly newsworthy. Of course, for me, it is newsworthy.
19 million is newsworthy. Yes. Round of applause.
Now, we have been encouraging the use of e-filing for filing cases. So, just to give you an example, we deal with, say, about 65, 70 cases. There have been times when we have dealt with 100 plus cases on a Monday and Friday. And our support staff would be carrying these piles of cases on their shoulders. All that is gone as a result of the pandemic. My entire universe of cases is now contained in a digitized form, which I operate on my laptop. The notes I make on my laptop, all the judgments which we dictate are given to us in a digitized form on the laptop. We edit them on the laptop, and our orders are uploaded on the internet. We have the National Judicial Data Grid. Those of you who are interested may actually like to surf the internet and just do a Google search on National Judicial Data Grid or NJDG. Now, we have 25 high courts. On the NJDG, we have 59.70 lakh cases which are pending in India. We have full details of those cases on the NJDG. There are 3.35 crore disposed of cases, details of all of which are available on the NJDG. As a result of which, we have details of 678 districts in India, 3,390 court complexes, 8,145 court establishments, and 21,061 courts. So the NJDG, for instance, contains comprehensive data, and it's really a mine of data for use on artificial intelligence, which is mapped on the NJDG. We have virtual courts, which have been set up during the pandemic. Now, one of the first uses of AI in the Indian judiciary was by setting up virtual courts. The Delhi High Court set up virtual courts, and close to 24 judges in Delhi were doing the work of traffic challans, traffic ticket cases. As a result of the setting up of virtual courts, the entire process is mapped on the electronic platform, and the work is pretty much formulated, and the work is handled by maybe one or a couple of judges. So imagine in terms of the access to the citizen. Normally a citizen who has to pay a fine can either pay the fine on the spot. If the policeman catches you, crossing the zebra line and says you have to pay 2,000 rupees, you can either pay the fine on the spot, or if you want to contest it, you have to go to court. If you have to go to court, you have to get a lawyer, spend a day. An auto rickshaw wala or a truck driver has to spend a day in court, go to the court, or if the case is adjourned, go multiple times. Now with virtual courts, all that they have to do is that they get the summons on the on a smartphone or any other phone that they have. You go to the State Bank of India, you pay the fine. That is logged on to the on the virtual register of the judge, and the case is knocked out of the system. So these are some of the instances where we have been able to leverage technology. But above all, on delays, and that's the human element, which I think is equally important, which is one of the reasons for Tariq Pe Tariq, as you know, one of the Hindi films.
Sunny Deol.
Yes. And one of the reasons.
You don't expect a Supreme Court justice to quote Sunny Deol.
One of the reasons for that is I think there has to be a change in the mindset on the part of lawyers as well. So often, you know, in the Supreme Court, even in the Supreme Court, a lot of us judges find that it's far easier to decide a case than it is sometimes to get a lawyer to argue a case. So I do believe that, you know, there has to be a change in mindsets so that lawyers are ready to get on with their cases, argue cases, not constantly be haranguing, you know, the judge when the judge wants to go ahead with the business of the court. And this I speak of the Supreme Court, where we have a degree of authority, because we are the final court. You can imagine what is the plight of a civil judge junior division sitting in a remote part of the country in a small taluka establishment. That judge can be, very often our judges are threatened. They might be told, well, if you act smart, we'll have you transferred from here. There are local pressure groups, and you're dealing with judges in their 20s and their 30s who are, in that sense, you know, who are trying to do justice. And there is so much that the judge can do, and there's so much that the bar should do as well, which I think it's important, therefore, that we change mindsets of lawyers as well and make them appreciate that merely because you have a client who may be on the losing side, you ought not to be doing every trick in the rule book to ensure that, you know, the case does not get heard. Very often you find that, you know, that lawyers are very eager to argue an application for bail. But when it actually comes to arguing a case finally in an appeal against a conviction, judges in the High Court also say it's very, very difficult to persuade lawyers to argue the criminal appeal. That's not the only reasons why criminal appeals are pending. Don't mistake me. Criminal appeals are also pending because of the lack of adequate number of judges. But very often then the judges are told by the lawyers, well, I've been only briefed to argue the application for bail. If you're not granting me bail pending the disposal of the appeal, I'm not going to argue the appeal today. So these mindsets have to change. And I don't know what we can do to ensure perhaps better legal education, changing the atmospherics in the courts. So the burden of this is not just on the judges, but on wider society, on the policy planners. So action has to be taken at multiple levels.
No, that's. I think that I would certainly agree with. A lot of action has to be taken, but I think one of the things that people will acknowledge, and perhaps we should, be the positives that, I mean, I didn't know about the way traffic crimes are now handled. This is a huge innovation, and we should celebrate the positives as well to get a sense of momentum. I would like to, of course, have the audience also have the opportunity to ask you questions. I don't want to monopolize your time all the time, but if I may ask one, I'll come back to that. But the Deputy High Commissioner had a question, which we'll have a mic come up to him. Okay, then I'll shoot to one more question of mine. That, do you think, this may be slightly technical, but much of the audience are lawyers, so they may understand this. Do you think that there is a problem that in the Supreme Court being a court of appeals and a constitutional court at the same time in India, so therefore lawyers who should be stepping back and mulling deeper constitutional questions, judges, are also forced to clog their bandwidth up listening to appeals? So they are kind of two competing functions. And is it better to have these, especially in such a large country, is it better to have that in two different courts? What are your thoughts on that?
There is, of course, we have models across the world where the Supreme Court is clearly demarcated as a constitutional court. I think the classical illustration is the US Supreme Court, which is a constitutional court, which of course hears cases bearing upon the constitutional issues under the US Constitution and state disputes which also implicate federal constitutional issues. Now, when the Indian Constitution was drafted, a different model was adopted. The Supreme Court is not just a constitutional court, the final arbiter of disputes in constitutional cases, but it is also a final appellate court. And the reason is that unlike the United States, where you have a dual judiciary, the state judiciary and the federal judiciary, in India, though of course we have this what is called the state judiciary, we have the district courts and then we have the high courts, but you have a unified judiciary in India. That is, you have the district courts in a state, the high courts, and then you have a Supreme Court. And there's a unified judiciary in that sense in India. Now, what the Constitution did was it gave the Supreme Court final appellate powers and it gave the Supreme Court constitutional powers as well, Article 32, to deal with disputes involving a violation of fundamental rights. The high courts have constitutional powers, Article 226, where they can deal with a violation of fundamental rights or any other legal right, but they are also courts of appeal. So an appeal, say, from an order of the district court lies to the high court, the first appeal, and then there's a special leave petition to the Supreme Court. An appeal against an order of a civil judge, the first appeal will go to the high court, a second appeal to the high court, and then the first appeal to the district court, the second appeal to the high court, and then the final Article 136 to the Supreme Court. Now, the Constitution says, and I don't want to get into the technicalities, the Constitution says that the Supreme Court can hear a petition where on an issue of substantial public interest arising from an order or judgment of any court or tribunal in India. Why did the Constitution do that? Again, very visionary drafters of the Constitution. The reason the Constitution did that was that they wanted that the Supreme Court should be this national unifying force for law and justice in the country. And that is a very significant aspiration which the drafters, led by Dr. Ambedkar and very distinguished members of the Constituent Assembly, came to adopt for India. They were conscious of the fact that this is essentially a very poor society, a society which is ridden by discrimination, caste, patriarchy, and they wanted this national court to be a sort of an umbrella unifying force for the whole of the country. We have to put ourselves back into what India was when the Constitution was framed. A nation which had suffered partition, a nation which had suffered the horrors of partition. So there was this aspiration that this would be a unifying institution, a national institution for the whole of the country. And now I'll tell you how it has panned out. It's very difficult sometimes to distinguish between something that is purely constitutional and something which is purely appellate. I'll give you a very simple example. Just a month ago, before we closed for the vacation, we had to decide an issue involving the goods and services tax. And the issue is whether goods and services tax can be levied on the ocean freight element in the case of a CIF contract, where the foreign exporter engages a foreign shipping line for the transportation of goods to India. Now, can GST be levied on the service element, namely the service which is rendered of shipping the goods to India? That was the point of tax law. But in the context of that, we had to also interpret the provisions of the GST law as it has been engrafted by the constitutional amendment in India. So this was one example where it was not just the appellate issue that we had to consider, but the constitutional issue. Apart from this judgment in Mohit Minerals, for instance, something as simple, I'll give you a very mundane, a seemingly mundane example. The union government came out with a policy that there shall be no transfers from one commissionerate to the other in the central excise department of the country. Now, this was challenged before the Supreme Court. Now, we had to deal with the issue because a lot of people challenge this on the ground that this works against the interests of women who will be denied a spousal transfer uh, because it is a transfer from one commissionerate in the country to another. A very simple issue of service law also involved constitutional issues. Is there a constitutional issue why two spouses who are both employees of the central government in the commissioner of in the central excise department must have, as a matter of fundamental rights, the ability to live together so as to promote their family life, to be of assistance to their children, to be associated with each other during the course of their service careers? Or another very interesting example recently before us, we dealt with the issue of disability, where the issue before the Supreme Court was, can a person who suffers from a writer's cramp and is appearing for the civil services exam, is he or she entitled to the facility of a scribe as a matter of right under the Rights of Persons with Disabilities Act, which Parliament has adopted? And we said they're entitled to it as a matter of right. Recently, we had a case where a constable in a paramilitary force was dismissed from service on the ground of misconduct. But the rub was that the constable was suffering from a mental health issue. So we said, well, you could not have dismissed the member of the paramilitary force from service merely because they were suffering from a mental health issue. The principle of reasonable accommodation, which our law embodies, requires you must accommodate them somewhere else where they may not have access, they will not have access to firearms. So you can do a non-sensitive job. Now, the reason why I mentioned these three examples is look at the width of the power which has been given to the Supreme Court. And this width of power has been given to the Supreme Court so that different high courts don't take conflicting views on legal rights while deciding cases. And you know, Article 142 of the Constitution, which is perhaps unique to our Supreme Court, Article 142 entrusts the Supreme Court with the power to do complete justice. So that even if you have to decide a case where the law is silent, for instance, the Supreme Court has been given that power, not any high court. And the framers probably understood that there may be some issues of the rights of citizens where ultimately you must entrust this power to the Supreme Court to do complete justice by issuing directions which will subserve the facts of that case without creating a precedent for the future in the high courts. So in that sense, while there is a great deal of merit doctrinally in the argument which was made that should you not have a Supreme Court which will exercise only constitutional powers, I'll say doctrinally, that's not the vision of our Constitution. The Constitution has envisioned this as a much broader institution in the context of poverty, in the context of discrimination, and as a national unifying force to produce one cohesive nation and to use the law to provide for legal principles which will knit together this nation of different cultures, different languages, different aspirations into one national society.
If anyone has any question, please raise your hand. But I'll just come because there's just, if you can allow me, just one question that builds on this, because actually it's a very complicated. Sorry, I'm the guy on the stage, so yeah, going to use that right. But because one thing which flows very naturally from, because the complexities of the issues that the judicial, and India is a complex country, all our government organs face such complexes. Is there a value in exploring something like an Indian judiciary service so that many of these issues can, if there's a service which goes through, the lower courts, high courts, a certain part can be directly appointed, certain part can go through the service. Is there a value in exploring something like that so that many of these issues then become a part of the discussions, training within the service, and therefore cascades down across? What do you think of that, sir?
Let me give you first the model which the Constitution has adopted. The Constitution has adopted a model where the district judiciaries in India are under the administrative control of the high courts. Now, therefore, appointments to the district judiciary are made within each state. And typically, the examinations which are held for recruitment of judges to the district judiciary are held in the state. There is no national examination. Appointments to the High Court are made not within the state, but they are made, of course, by the President of India. There is a detailed procedure under the Memorandum of Procedure which has been adopted for making appointments to High Court judges. Now, in the district judiciary, judges are appointed from two sources. Judges can be appointed at the lowest level, which is the level of the Civil Judge Junior Division or the magisterial level. Judges are also appointed laterally at a more senior level as district judges after putting a stipulated number of years of service. To the High Courts, the Constitution has adopted a dual framework, namely that lawyers can be appointed as judges of the High Court after putting in a stipulated number of years of practice, or lawyers can, or the district judges can be promoted to the High Court, provided they have a certain degree of seniority or stipulated number of years as district judges. And of course, to the Supreme Court, you can have appointments which are made from three sources, from the High Courts. Therefore, district judges who have come to the High Courts can become judges of the Supreme Court. Lawyers who have been appointed to the High Court can become judges of the Supreme Court. For the Supreme Court, there is a third source, which is the source of an eminent jurist. There has been no appointment over the last 70 plus years of an eminent jurist, but that's a provision which is made in the Constitution. Now, the proposal which was initiated initially in 1958 by the Law Commission and which was being also discussed in 1992 in the All India Judges Association case by the Supreme Court, but it was ultimately left by the Supreme Court to the Union of India to take an initiative on this issue. 2017, the Supreme Court again took notice of it of its own accord. The proposal was really that you can have an All India Judicial Service so that you can have appointments to the district judiciary, which is really in that sense monitored or supervised by a national umbrella authority. And one of the considerations, I really don't want to go into the merits of the proposal because it's still pending consideration before the government and at the Supreme Court, and therefore I'll not hazard an opinion, but I'll just broadly indicate what the contours of the proposal or the contours of the issues which arise are, which is that very often there is a delay in the process of appointment of district judges. The Supreme Court is monitoring that process in a case which is very famously known as the Malik Mazhar Sultan case. So, because the High Courts make those appointments, the High Courts make those appointments in consultation with the